concurrence of finance. Well, at this stage, I don't really need to take your lordships through the rest of the contentions that we have made in the affidavit. But there is one judgment that I do want to, my lords, draw your lordships' kind attention to. If I can hand over this. So we have, my lords, given compilation for 3 or 4 prepositions. They are settled law. I am not bothering your lordships with that. The prepositions that we have, my lords, given is, one is, my lords, how the PIL is not maintainable in service law, limited scope of judicial review, my lords, on malice in law and malice in fact. We've also given judgments on how appointment is not a right, but this I want to show to you. My lords, no, this I want to show to you. Lords, permit me to just show 2 or 3 paras. My lords, this is the Char Dham judgment that it's commonly known as, my lord. This was a case where the Ministry of Defense filed an application before the Honorable Supreme Court for modification of an earlier judgment of the Supreme Court. Modification of an earlier order of the Honorable Supreme Court, my lords. If your lordships will kindly see, your Chief Justice's judgment has, my lords, interesting index. So F.1.3 is what I will take your lordships to. But please have para 18 first. Para 18 would be at internal page. No pagination, I'm sorry, my lords. Para 18, your lordships will find that this MA was filed by Union of India. My lords, para 18, I just want to show what the court was considering when I take your lordships to those papers. That Union of India, through Ministry of Defense, filed an MA seeking modification of this court's order of so-and-so, which is also subject matter of this judgment. And the permission was for widening of national highways from Rishikesh to Mana, Mana to Gangotri, Tanak, etc., on the ground that these were critical for national, for the defense purposes. Now, if your lordships will kindly have from para 75 onwards, where the analysis on the width of road starts, and if I can take your lordships to relevant paras, which are 79, 80, and 81, just a few lines I want to place for your lordships' kind consideration. In the background of that MA, my lords, the Honorable Court holds in para 79 that at the outset we find that there are no malafides in the MA filed by MOD. The contention was that MOD has filed this application by malafides. No, my lords. No, I agree, but please see.
They're not even saying that strengthen is key.
I bow down.
They're only saying
reconsider.
According to them, probably need a reader.
Well, that is why I pointed out para 15 at the end.
They have not said that it's bad. They
I
have
bow
not
down.
said that it has ultra-violence. They have not said it has the right of anti-competence.
Well,
Only saying these are a few things which they feel have been overlooked by.
yes.
And so please exercise this power
So, my
and
lords,
direct the government to have a reason.
so, my lords, 2 things. Firstly, my lords, they have not said all this because there is probably no occasion for them to say this. Secondly, your lordships may note one aspect, my lords. While Indian Army is 12 lakh plus standing force, we have 32 lakh veterans. Each one is entitled to their own opinion. They are all experts in their fields. But, my lords, please see once the Ministry of Defense takes para 79, I wanted to show. The malafides is the background there that was taken, that the contention of malafides was taken and how the Supreme Court deals with it in para 79. The allegation that application of MOD seeks to re-agitate the matter and subvert the previous order is unfounded in as much as MOD, as the specialized body of the Government of India, is entitled to decide on the operational requirements of the armed forces. These requirements include infrastructural support needed for facilitating the movement of the troops, equipment, and machines. Please come to para 80, my lords. They had pointed out a statement made by the then Chief of Army Staff in the media that enough infrastructure was available. And so here also some expert reports are quoted. My lords, I want to read 80 also. Please permit me to see in the background of this Chief of Army Staff's interview, in para 80, third sentence, the court says, the security concerns as assessed by the MOD may change over time. Recent past has thrown up serious challenges to national security. Armed forces cannot be held down to a statement made during a media interaction in 2019 as if it were a decree written stone. And then please see para 81. This court, in exercise of judicial review, cannot second guess the infrastructural needs of the armed forces. The appellants would have this court hold that the need of army will be subserved better by disaster resistant roads of a smaller dimension. The submissions of the appellants required the court to override the modalities decided by the army and the MOD to safeguard the security of the nation's border. The submission of the appellant requires the court to interrogate the policy choice of the establishment, which is entrusted by law with the defense of the nation. This is impermissible. Well, because this was an application of the Ministry of Defense, and my lords, there are several things which we could say on affidavit. There are several that we cannot say on affidavit, my lords. That is why our first submission, though I did not read it, my lords, in the affidavit was that this is a sovereign function, my lords. Defense of the nation. In fact, my lords, from Vidyavati onwards, your lordships have completely diluted the concept of sovereign but defense forces, my lords. Especially forces like Indian forces, which are not, my lords, security guards for a FIFA Cup. They need to be, my lords, given a much bigger leeway when they are taking a well-considered policy decision. And, my lords, this is work in progress. Any operational issues that arise, if there are any, my lords, it is in our interest to have our nation's forces at the highest pedestal, at the most amount of morale and motivation. If there are any issues that we find, my lords, they will be ironed out. I can assure your lordships of that. And if your lordships wish to see, my lords, the expert committee reports, I have, my lords, those for your lordships, if your lordships wish to see. My lords, I'm great. I'm sorry. Yes. My lords, I'm grateful for your lordship. Kind indulgence. We will file an affidavit on the roles and responsibilities.
भाई अभी तो फिलहाल जो है हम ये कर रहे हैं, ये मेरे दोस्त ने बताना भी है क्या हुआ है। तो मेरे फ्रेंड्स हैं, मेरा टाइम था ही है। हम लोग जो है कोचिंग
Malord. The 2-3 point, Malord, Malord has already taken concern of that point, whatever I have given last submission, Malord. Malord, this is the scheme which they have given, Malord. And the same, if you see the first page of the scheme, they say attractive opportunity to apply for enrollment in permanent cadre. Opportunity to apply for enrollment in permanent cadre. I just wanted to know what is the status of the Agniveer, what the my lord has taken. And here at the recruitment, candidates will be enrolled under this respective service act. Whether they are enrolled or not, that is the important aspect, my lord, because that is one to which they have to bring out, my lord. Because service conditions, the applicability of subjection of act, disciplinary proceedings, and other procedures which are there in the Army Act has to be amended accordingly. That is what the submission, my lord. Why there is a discussion in the Parliament required as per the law? Because of the act.
For job after the agreement scheme, they provided a chart for sending.
They are saying working on it.
No, they are not saying.
101. My lord, I accept that. I accept that.
That chart is only with respect to the military. And they say that the state government will also provide reservation in state police forces, in state paramilitary forces.
My lord, that is.
Some of the state governments, if I'm not wrong, have already announced that kind of scheme.
It is not in writing, my lord. We have checked it. My lord, I'll check it. My lord is considering this part. My lord, one argument was there. 8th class, my lord. 8th class, this is over standard of the 8th class. The student is under, I think, 13 years of age for experience. 8th class is the first. That's what, my lord. If they are coming for a training, my lord. My lord, I've got it. My lord. My lord. If they are coming for the training, my lord, and one ground what types it. My lord. That's what, my lord. 2 points, my lord. One is the training aspect which my lord is considered. The other point is the risk factor. they are going to put them under risk because they are committing or not committing. My lord has to check whether they have to perform the same job what the Sipahi is doing. And if they are not performing, then who is looking after the security and what about the deficiency of that part? The 3 years deficient soldiers already, my lord. And now what will happen if you are taking as a training because we are already deficient right now? I think, my lord, it is 8 point something is this strength. Wherein, my lord, Galwan is started, my lord. They have already started and this is going on still. I am just telling, my lord, because I am not against anyone. I am only against that part which has to be taken care as a citizen, as a veteran, as a responsible man, because I have seen that thing is on ground and it is going to give a heavy load on the Sipahis as well as the NCOs, my lord. It's ground where they will employ them. They can't put them on the, because, my lord, as per our policies, 4 years is the minimum service when we take the man to a bunker. There are weapons sophisticated. There is a war establishment table, peace establishment table, which is established for a weapon. My lord. My lord, that's why, my lord, I can bring out my experience only for the purpose.
To adjudicate or decide between two opinions conflicting together and go
My lord, my lord. But it attracts the Article 21, my lord. My lord.
Saying that if the policy is, and if it is not attacked by a very what's
my lord, I'll cut it short and I'll just, my lord, I'll get to that part only. Article 21, right to life, my lord. Youths are also our responsibility, and that is what, my lord, I'm bringing out the risk factor.
the government does not take care of you. What kind of argument is
It's still, ma'am, my lord, because it has not implemented. It is going to affect after effects, my lord. This is the thing which has to be, which cannot be ruled out. They have to consider this part. That is what my submission is. Because deficiency is there, my lord.
in their affidavit, they have stated.
My lord,
My lords, this will conclude, if your lordships have page 9, so this will conclude everything in category 1, my lords. 10 matters.
The matters which are confined only to
Yes, so first 10 matters in that category. Yes, my lords.
Officer's case and yes, come on both.
and then one part is the second part.
Yes, so second part here. Yes.
my lord, one thing is again an important aspect, my lord. These 75% when they are coming, they are aware about the prohibited places of the army. Aware about the prohibited places of the army. They are well trained. My lord, there is a GPS, my lord. There are locations which are not to be. My lord, why I am telling you, they all are under Officer Secret Act.
Full sense of response.
Yes.
I know certain cases which you are lost.
My lord, I can handle. This is the only aspect, my lord. Concern, nothing else, my lord. It's the only concern, my lord.
And with due respect.
Yeah, if they are working on it, it's fine.
May I request your lordship to take up the. Yes.
Yes, which is your number.
Lord, it's writ petition 10023 of 22. 39, item 39. ठीक है तुम नहीं
Yes.
Sir, is in 1002.
पढ़ लो
1002.
yes yes
Yes.
Lord, the prayers are at page 31.
Sir, cover one of the
Yes.
cases
Yes.
and from his case
Two matters plus mine covered was that is item 40 and 43.
number, sir.
40, 40 and 43.
Item 45.
I think that charge is already then the
Very, very.
Bed job. So, my lord, the prayer is at page 31. I have not challenged the Agnipath scheme, the Agniveer. Although, my lord, just by way of what I have read about the scheme and what I understand about the scheme, and what I have read, what several retired generals have said about it, the impression that I got was that proper and full consultations have not really taken place among the various experts and the wings of the forces, as well as from other retired experts, etc., with them before this scheme was announced. And it was announced quite suddenly because, in our case, my lord, the advertisement is of 2019 recruitment of these airmen. The uh, select list was published in May 21. In December 2019. 11 December 2019. If I had to challenge the Agniveer, I have not challenged it. I'm just saying, if I had to challenge it, the reason why I have not challenged it is because, my lord, I wasn't very sure as to how much consultation has actually taken place, whether all the experts were brought on board, whether proper consultations took place before, and every aspect of it was considered or not. Because the impression that I get from reading the statements made by a number of retired generals is that proper consultations perhaps did not take place. The government in their reply says that no, this we discussed it for 2 years. And they start with that Subramaniam committee formed in the wake of the Kargil war. That, of course, was a long time back. That's a very general thing about some youthfulness, etc., because in that case, the war was at a place where, of course, physical endurance is always an issue in the armed forces. So perhaps in that context, they said something about youthfulness, etc. But the counter affidavit does not give a very clear picture as to who was consulted, how these consultations take place, what kind of recommendations were made by different bodies which were consulted, etc. That doesn't appear to be there. But since I was not aware of what really happened, so I was not in a position to challenge the scheme. There may be good reason. I'm not denying that there is no good reason at all for the scheme. But what I have come up against is our recruitment. All the petitioners in this case, there are a very large number of petitioners, are people who were in the provisional select list, in the select list. And that select list came in May 2021, 31st May 2021. And from May 21 till May 22, they were continuously told, every 2 months they were being told, that the call letters are being delayed and they will be issued in due course. First they said COVID, then they said administrative reasons. So we have mentioned those. So the advertisement is at page 34. Prayer is at page 31. Prayer is a simple one, that at least our recruitments, which had been almost completed, only thing that was awaited was the call letters. Selections were done, medical exams were done, everything was done. And only the call letters. And we had been awaiting the call letters for more than 1 year. When suddenly, by means of a press conference, we filed this petition, my lord, on 4th of July 2022. By that time, not even a formal announcement was made, nor notification issued saying that we are cancelling your recruitment on account of this new scheme. No such announcement was made formal. All that we learned was from a press conference addressed by the Air Chief, where he said, and that press conference, my lord, is of 14th June 2022. From that we learned, yes. So what I'm saying is,
basic issue is
yes,
inclusion of the select list. Does it create a right?
may not be creating a right. Yes, my lord. I'm not saying that it creates.
This is not in dispute. They are not disputed.
Yes, yes.
Now, nowadays, I have been subjected to a process of selection.
Yeah.
My name finds place in this select list,
Yeah.
and therefore I should be given a point.
No, my lord. That's not my case.
Then what is your case?
Yes, my lord. My case is, they said in the advertisement that this will be the process of recruitment. They never said in the advertisement that we can stop the recruitment at any time. It's true that the general law is that the mere selection does not create a legal right for being appointed. But, my lord, I am saying that in these circumstances, that is, circumstance number one, that the process had gone on for 1.5 years when the selection finally takes place after going through everything. Thereafter, my lord, for 1 year thereafter. No, no, they keep telling me that we are going to do it. We are going to do it. It's delayed due to COVID. Then they say it's delayed due to administrative reasons. Every time they say we are going to do it. And during that time, many of us were selected in BSF, various paramilitary forces. And we let go of those appointments. We've decided to forego those. They were confirmed jobs. Call letters had been issued to us. And we decided to forego that because we were certain that this recruitment would happen. Because if the government, as they are saying, that we had discussions and consultations for 2 years. 2 years meaning 2 years prior to June 2022. June 2022, they announced the Agnipath scheme. And for the first time, then, my lord, by means of a press conference, not even by means of a formal notification or a formal announcement, nor by telling us formally that your recruitment stands cancelled because of this. That happened thereafter, my lord, formal thing came in August. After we filed this petition, in their response to this petition, counter affidavit, they say that we are now not going to proceed with that. Now all recruitments will be through Agnipath. So the question is, my lord, there are two doctrines which have been founded by the courts. One is promissory estoppel, and the other is legitimate expectation. Promissory estoppel is the doctrine where the courts have said that if a promise has been made to you of something going to be given to you, and if on the basis of that promise you have altered your position to your detriment, then, my lord, they will be held to that promise. That's the principle of promissory estoppel. I have changed my position to my detriment by foregoing the jobs that were offered to me in the meantime. I was offered those jobs. I have annexed the call letters. And I've decided to forego those jobs on the expectation that my appointment is coming. They are only saying COVID and then administrative reasons, etc. Every 2 months they are saying that. And therefore, my lord, I was expecting. The second principle is legitimate expectation. When the government offers something, even if I have not changed my position to my detriment, if the government changes its position arbitrarily, without any good reason, then, my lord, the principle of legitimate expectation kicks in. And these two principles, my lord, there are a large number of decisions which expound these two. But broadly, my lord, these are the principles. Now, in this case, the government is saying that, well, they decided when? In June, when they announced the scheme. Till that time, there was no decision. My recruitment selection had taken place in May 21. They say that they decide in June 2022 that henceforth, they didn't even inform me that we are putting your thing on hold for the reason that we are considering a new scheme and therefore your thing may be cancelled. They didn't say that at any stage. They just kept telling me that it is postponed due to COVID and then due to administrative reasons. Now, the question is, my lord, even if they say that they have done so because they have taken a decision that henceforth all recruitments will be through Agniveer, I submit, my lord, cancelling a recruitment of this kind, which started 2.5 years ago, which concluded by a selection more than a year ago, where for the last more than 1 year, they kept telling me that it's just due to some unavoidable reasons, but it will happen. Then, my lord, and where they are saying that for achieving the objective that they want to achieve by way of this new scheme, it's going to take them more than 10 years. That is to bring down the average age, etc., to bring it to a ratio of 1:1, etc. It's going to take them more than 10 years. I submit, my lord, it is totally unfair, unreasonable, and arbitrary for them to have stopped this recruitment at this stage. That's, my lord, totally arbitrary, and therefore it is hit by the doctrine of legitimate expectation. Quite apart from the fact that in our case, there is also, we have altered our position to our detriment. We have foregone. Yes. So now, my lord, your lordship may see those documents. The first is the advertisement, which is at page 34. Now, this is an advertisement of 11th December 2019, calling for these recruitments. And if your lordship sees at page 35, on the top, it says first there is an online test, then candidates 17, it says candidates are to qualify in each paper separately in their respective groups. Thereafter, my lord, phase 2. Soon after the declaration of phase 1 online, a cutoff will be applied based on the marks scored, and shortlisted candidates will be sent a new admit card for their registered email for phase 2 at an airman selection center, their admit card, etc. Thereafter, my lord, physical fitness 20, physical fitness test, then adaptability test 22, and then phase 3, again medical exam, etc. And then they say at 30, provisional select list thereafter. And then enrollment list. Nowhere does this advertisement say that the government reserves its right to cancel this process at any stage. It doesn't say that. It's another matter that the selection by itself may not legally guarantee a job. Legal right is not yet created by just the selection, and the legal right comes when they issue a letter of appointment. But my lord, after this, then they publish the provisional select list, which is at page 67 onwards, and that's 31st May 2021. Okay.
Yes. B2 is the letter.
PP4.